Recently, I had a discussion with a potential new client who had called us to get some legal advice and some questions answered. And one of the things they were concerned about is the difference between a provisional and a non-provisional application when it comes to information that is disclosed in either one of the application. The simple answer is there should be no difference between the provisional and the non-provisional application when it comes to information that is disclosed at the time you're aware of it. My name is Jubin Dana. I'm with Dana Legal Services, and we focus on patents and how to get patents that are valuable in terms of your revenue stream. And if you file a provisional application that doesn't have enough detail in it, or in the case of my discussion with this potential new client, they said that, well, we want to put everything into the provisional, and then when we file the non-provisional, we only want to worry about one or two of the concepts. I told them that regardless of whether it's a provisional or non-provisional, you really need to take the time to write as much detail as possible. People think that provisional applications are cheaper because the filing fees are different from non-provisional. Yes, that's true. Provisional applications are only about a $200 filing fee, which is the fee you pay to the US Patent Office, versus like a $850 fee, which is the fee you pay to the Patent Office for a non-provisional. Yes, there is a difference between those two of about $700. However, that difference is only in terms of the fees that you pay. It doesn't translate into a difference in terms of the information you put in the provisional versus the information you put in the non-provisional. If you get someone to write you a provisional application and they say, oh, I'm going to spend 2 hours on it. And that, by the way, we have a whole video explaining on how to hire your patent attorney when it comes to knowing what the costs are, because we really encourage you to understand the time that the patent attorney is going to spend, not the dollars they're going to charge you. It is really important because, again, like I was saying, if you have a provisional application and someone's only going to spend 2 hours on it, and you're filing a non-provisional and someone's going to spend 7 or 8 or 9 or 10 hours on it, there's a huge difference in the information that goes into those two applications. 2 hours worth of work is not the same content and the same amount of detail and the same amount of information as 7 to 8 to 9 hours of work. However, when it comes time to turn your provisional application into a non-provisional application, any information you didn't disclose in the provisional is considered new material, so it only gets the date that you convert to a non-provisional. All the stuff that's in the provisional, sure, that gets the provisional date when you convert it. So it's really important to understand that the real difference between a provisional application and the non-provisional application should be in the amount of time the attorney spends writing claims. Why? Because provisional applications don't require claims. So I can in 15, 20 minutes write a claim that's just one simple claim that in general covers the idea and leave it at that. However, when I go to file the non-provisional application, I'm taking into account the idea, how that idea ties to the various revenue streams you've identified, in order to make sure that your claim sets protects your idea and your revenue stream. So there's a lot more time spent preparing the claims. Just to be scientific about all of this, about 70% of a non-provisional application time is spent drafting the detailed description, the figures, so forth, maybe 75%. And then about 25 to 30% of the time is spent writing the claims. So if you're going to file a provisional versus a non-provisional to save filing fee costs, there will only be a difference in the attorney's time in terms of writing the claims or not. The rest should be pretty much the same. Unless, of course, it's last day or it's something that you're going to disclose tomorrow and you put your attorney in a position where they can only spend a couple of hours, in which case, fine. You tell your attorney, hey, here's what I have. Here's the PowerPoint slides I'm going to share. Here's the information that I'm going to put out there. So can you file a provisional on this? And of course, the attorney can take and spend a couple of hours and just take what you have and format it so it looks like a proper provisional application, and then file it for you with whatever figures you have attached to it. That being said, the difference between a provisional application and a non-provisional application should really be just in whether or not the claims are written. It should not be in the amount of detailed description that's disclosed, because the more you disclose at the time you file your provisional, the more content you have that you can convert to a non-provisional. My name is Jubin with Dana Legal Services. Here's our contact info. Please reach out, ask questions. We'll be happy to help you.